In our constitutional system, there's many checks and balances that protect our individual right to keep and bear arms. Certainly the Second Amendment is one such check, but there's others. That's why I want to talk a little bit about the Democrats' January 6th report and some of the things they just did as they left office. I think you'll find it interesting and important to our rights. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. We're working really hard to try to get to 100,000 subscribers to help us out with the social media algorithms. So there's many ways that our right to keep and bear arms gets protected. The text of the Second Amendment is certainly one of them. There's notions of federalism, which means that power resides not just in the federal government, but also in the states and local governments. And also there's other structural constitutional protections, such as things like the filibuster that makes it harder for the United States Senate to just run roughshod over our individual rights. But I want to talk really about three lessons that have arisen over the last week or so associated with the release of the January 6, 2020 report by the Democrats in the House side of Congress as they were leaving office, basically, or leaving their power structure. This is something a little bit unusual. What it really is important to understand, and I don't want to get bogged down in the details of the January 6th stuff. I just want to hit three highlights that I think you need to know as part of Second Amendment advocates or part of the Second Amendment community. And those are the following three things. It turns out that the last thing that the Congress did was enact this sort of omnibus budget of $1.7 trillion. We'll set the issue of spending aside and how it's going to cause inflation. And I just want to focus on one thing, which is that part of that massive, crazy 4,000 plus page bill that got passed by the Congress and signed into law by the president, one of the things that was in there was the Electoral Count Reform Act, which changed the Electoral College, which actually turns out to vindicate, in many respects, I think you could argue, Donald Trump's view of how the Electoral College system could work. And I'll explain that in just a second. The second thing is the January 6th report specifically turns out that, as you may recall, Clarence Thomas, who is the author of the Nysurpa versus Bruin decision, obviously liberals hate Clarence Thomas because his rulings tend to be against what they want. They want judges that just do whatever that liberals want, what progressives want, and Clarence Thomas follows the law, including the text of the Second Amendment, and they hate him for that. So one of the ways I think they tried to go back and get him and to hurt him as well as to discredit him, I don't think it worked, but they tried, was to try to depose and harass, as I see it, through the testimony of his wife, Ginni Thomas, associated with the January 6th stuff, because of a handful of texts that she sent to Mark Meadows, the chief of staff for President Trump. Well, as it turns out, when they issued their final report, how important was Ginni Thomas? Well, it turns out the final report, which was very, very long, involving January 6th, doesn't even mention Clarence Thomas's wife, Ginni Thomas. So if she's so irrelevant, right, if she was totally irrelevant to the January 6th stuff, why did they waste people's times and drag her in to have her give a deposition and give sworn statements and do all sorts of things and to try to embarrass her? If she was such an irrelevant player, she doesn't even get mentioned in the final January 6th report. Inquiring minds would like to know. And the last thing I want to mention, of course, is what's the story with conservative judges versus liberal judges, and why is it so hard for conservatives to get good judges, and liberals, why is it so easy for liberals to get judges that advance the liberal way? I want to discuss that in just 1 second. But I want to step back first and foremost and talk about this Electoral Count Reform Act, which was just enacted. Remember, the entire argument that President Trump had, now you can disagree with what he said. There's legal arguments going both ways, but nevertheless, here's what's interesting. President Trump's argument was that Vice President Pence, when he presided over the counting of the Electoral College votes, right? That's what he did. He presided over it. The argument was that Mike Pence, as Vice President, overseeing that process, had the legal authority under the Electoral Count Act of something like 1897, I think that's when it was enacted, to basically set aside certain results if they looked irregular, or to conduct an audit of them to make sure that those results in particular states were legitimate. That was the argument. Now, it did not prevail, and that's perfectly fine, whatever. The point, though, is that whether or not you think whether or not you agree or disagree with the argument, it turns out that Congress has just vindicated the fact that the Electoral Count Act of the late 19th century was ambiguous, which opened the door to President Trump's legal argument. And give you an example here. Here is a statement from Senator Susan Collins, a Republican from Maine, and Senator Joe Manchin, the Democratic senator from West Virginia. Now, tell me if this sounds interesting. They wrote that the Senate's Electoral Count Act reform effort is the result of nearly a year of bipartisan negotiation, etc., etc. But here's the key point. They write, quote, "Our bipartisan group worked tirelessly to draft this legislation." Here's the key. Here's the key, what I'm about to say. To draft this legislation that fixes the flaws of the archaic and ambiguous Electoral Count Act of 1887 and establishes clear guidelines for our system of certifying and counting electoral votes for president and vice president, close quote. You see what I just read there? Here is Joe Manchin and Susan Collins admitting that Trump's legal arguments, right, they may not have been the best arguments, but they were not frivolous because they are admitting, as did the Congress, that the Electoral Count Act as it existed in January 2020 was ambiguous as to the role of the vice president. Now, again, you can argue who's right and wrong, and that's not what I'm here to do. All I'm going to say is, to the extent anyone says that Trump's arguments were frivolous, the fact that Congress felt the need to clarify and resolve ambiguities of the existing law that existed in January 2020, I think vindicates his view that there was wiggle room there and arguments that could have been made that Mike Pence could have taken certain steps to address any alleged irregularities. Again, history is history. Now we move forward. But it is interesting that Congress has basically vindicated the view that the Electoral Count Act did give wiggle room to President Trump in his legal arguments. The second thing, again, is that the harassment of Ginni Thomas, as I see it, why did they spend all that time and money, and how much time and effort and op-ed pages were discussed about Ginni Thomas being involved in January 6th? But it turns out she was so not involved in the January 6th events that she didn't even her name doesn't even appear in the final report of the Democrats. That's how irrelevant she was. So it gives rise to, why did they bother to call her in there and ask her a bunch of questions other than to embarrass her, and by extension to embarrass her husband, Clarence Thomas, the author of Nysurper versus Bruin. I do not think that that connection is a coincidence. It's something that you should just be aware of, that again, whenever they mention Ginni Thomas and Clarence Thomas's connection as husband and wife, set aside the fact that, people are married to prominent people all the time in Washington. It's the way the world works. That's who you hang out with. That's who you wind up marrying, because everyone is in and around government in Washington. That's the industry of Washington, right? Set aside the fact that's kind of a non-event. The fact is the Democrats tried to get some dirt on Ginni Thomas, and although they had several fun weeks of harassing her in the press, it turns out her name doesn't even appear in the final report of the January 6th, showing how irrelevant she was. And last but not least, I just want to touch on one thing when it comes to Clarence Thomas. One of the interesting things it's important to understand as conservatives or as people that support the Second Amendment is that when Republicans appoint individuals to the federal bench, a lot of times they're appointed because of their judicial philosophy. They're strict constructionists, they're originalists, they're textualists. They have a jurisprudence, a philosophy, judicial philosophy that they apply, and whatever the result is, the result is. The problem is when it comes to liberals, and this is not a problem for liberals, it's a problem for conservatives assessing liberals, is at the end of the day, you see liberal/progressives, when they sit on the federal bench, their ideology is not to follow the law as it's written so much. Their ideology is to use the courts as an arm of government to advance what they consider to be a better world, which in their view is a progressive world. For example, no one can tell me what is the jurisprudential philosophy of Ruth Bader Ginsburg other than she always voted for the left-wing progressive cause and everything from abortion to gay marriage and so on and so on. That was her philosophy. You can't tell me she was like a Justice Scalia originalist, which was to apply the text of the Constitution and then the history of it associated with what the Founding Fathers intended. That's something Justice Scalia was, and sometimes that gave rise to results that politically they might not have liked, but they did it. But when it comes to liberal justices, I'm sure people like Justice Brown Jackson and Justice Kagan, they're all the same. At the end of the day, they view their job as a government actor and the courts trying to do good. The problem is, of course, their definition of doing good is to advance the progressive agenda and not the American agenda, as I see it, not to follow the Constitution as it's written. So I think that's why you sometimes see conservative justices make rulings that seem anti-conservative because they're applying their judicial philosophy, but the left has it a lot easier because the left has no judicial philosophy other than the results being advancing their political agenda. Okay, so hope you learned a little bit something here at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.